Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Friday, May 15th, 2026 at like 10:17 in the morning. So first off, we will take a look at an amendment for H639. I think I mentioned this yesterday to the committee. I went down to Senate Economic Development this morning. However, they did not have time to um, take me. I just like got bumped. So I did let the chair know that instead of waiting and pushing this off another day, that we would amend the bill with the amendment we talked about yesterday. We'll do that today and send it over to. I will be on their schedule. They have a Zoom meeting on Monday, so she's asked me to join them so I can explain at that point. But they should get the bill, I'm thinking Monday or Tuesday, depending on whether or not they have a token session or not. So I have asked Rick to come in and walk us through the amendment. I think it's an amendment we've seen before. Only changes, I've asked them to change it from 14 days, 0 to 60 days, which is aligns with what the Senate had sent over to us. The only thing it does is remove genetic data from the cure period. Rick.
All right, good morning. Rick Sagal with the Office of Legislative Counsel. If I could first show just as a refresher, the Senate proposal of amendment, because that is what is going to be on the floor for vote at first, is the Senate proposal of amendment. And as a reminder, they have two instances. The first one is a fairly technical amendment correcting the biometric data of consumers to biological samples. I just explained that, but as a refresher, that is not being amended by the chair's proposed amendment. So the first one, if you decide to adopt the amendment, that would remain in the bill. The second instance is from the Senate, where the right to a civil action from a consumer would be subject to a 60-day cure, including genetic data. The entire genetic data bill, if there is an alleged violation, the consumer would have to send a letter, some kind of notice to the company, and then wait 60 days before they could file suit. Right? That is the Senate proposal. I have on the screen now draft 1.1 of Chair Marcotte's proposed amendment that would strike out the Senate's proposal of a cure period and replace it with a different structure of the cure period. So as the chair talked about, a consumer that pursues a civil action against a direct-to-consumer genetic testing company or a service provider for an alleged violation, and there's three types of violations that would be subject to a cure. 2421BA1, I'm actually going to show you what that is, because I bet you don't remember what 2421BA1 is. I don't know why I looked at you. I didn't. It's not. You're just right here. You know,
I'm right there.
I got two people close to me, and I happen to look to my right. So 2421BA1 is privacy terms and consent. So if a direct-to-consumer genetic testing company did not provide a clear and complete information regarding their policies, use, disclosure of genetic data, including a summary of their privacy practices, a prominent, easily accessible privacy notice, down stopping at 2, that would be subject to a cure period. So a consumer would have to wait 60 days to sue for not having a privacy notice, but that's not really, there's not going to be many damages there for consumer. So, but it would still be subject to a 60-day cure. The other two, so starting at number 2 here, this would not be subject to a cure. So if a direct consumer company did not obtain a consumer's express consent for the following things of their genetic data, and my understanding is that this is the type of thing you want to protect. If they let someone else access it, if they store it somewhere after they tested it that you didn't approve to, all of these uses under 2 would not be subject to a cure period. Subsection B, the marketing exception, would be subject to a cure. So if a direct-to-consumer testing company violated B by not receiving consent or by basically marketing them in a way that violates the bill, 60 days to cure before the consumer could file a civil action. And the last cure period is down. So all this data security and access, revoking consent, not subject to a cure. Subsection E also contracts not subject to a cure. Subsection F, discrimination. So if a direct-to-consumer testing company or a person or public entity discriminated against a consumer because they exercise their rights under this chapter, there would be a 60-day cure for the consumer before they could file a civil action. All right, back to the amendment. So if that company does not cure the violation within 60 days, or if there's a disagreement as to whether the violation has been cured, the consumer shall have a right to initiate a civil action. And then number 3, there's no cure period for any other alleged violation. This matches almost exactly. You considered a committee amendment during this bill. The difference was, I believe it was 15 days or 14 days, can't remember. So now it's 60. So this matches the Senate proposed cure period. And that would be the proposal by the chair.
I can do the term of months.
Whatever you want, I'm happy to, I'd be happy.
Put the amendment in.
Just Rep. Olson.
Okay, any questions?
I just want to state for the record, I think a 60-day cure period is significantly too long. And I understand that we're at the end of session, and I hope that we can put a reasonable cure period in place in future biennia. In this digital age, dealing with these kind of things, 14 days is perfectly reasonable for a cure period.
Yeah, I mean, I totally agree. I call it a waiting period for affirming a consumer right, rather than, well, I agree, it's too long.
The unfortunate thing is
Here we go.
we have a Senate proposal of amendment, we're kind of splitting it. Giving deference to their thoughts on it.
Go.
I also would like to add to that, we do feel a little uncomfortable about it being so long, but I'm sure we can do some more.
So, all in favor of the now Olson amendment to the Senate proposal of amendment, raise your hand. Opposed? 11-0. So if you can transmit that to clerk's office, to Nigel.
So to you, Rep. Olson, and I'll copy Nigel, but you're going to have to say that I approve this amendment. Yes.
Yeah,
Yes.
on to S-198.
Good morning, Jen Carby, Office of Legislative Counsel. I will put the language up on the screen. Actually, just did a brief amendment that I will mention while it was upstairs. So I've had Jonathan swap out the version, which he has done. So this is a proposed amendment from Representative Kornheiser that was supported in Ways and Means when I just went through it with them. This is S-198, so we're in the tobacco products, tobacco substitutes bill. Section 11 was the report on taxation of tobacco substitutes, tax stamps, other things. And as we had looked at it together in the past, it has had the Department of Taxes leading it. the Office of the Attorney General had proposed that they lead it instead, which I understand was the Department of Taxes was amenable to, and they've changed the language a bit, although keeping much of the substance of what was in the bill that came out of this committee and others. So Section 11 would come out, but go back in with the Office of the Attorney General in charge in collaboration with the Departments of Taxes and of Liquor and Lottery. So the same three entities, but just shifting around who's running it. And in consultation with the wholesalers and other interest stakeholders, they would still be identifying efficient and effective processes by which to impose taxes on tobacco products and tobacco substitutes. This would be clarifying, we're talking about the definitions in the tobacco chapter as amended by this act. Still looking at opportunities to base taxation on a product's nicotine concentration, but it's including that. Also looking at the basing taxation on the volume of a product's nicotine tank or both. Calling out a couple of things specifically to look at. And also continuing to look at evaluating the continued use of tax stamps in this state as evidence of tax compliance for tobacco products and tobacco substitutes. So specifically calling those out. Also specifically referencing exploring the potential to transition to a more modern process, such as QR codes or other digitized systems. And then keeping language saying, considering the advantages and disadvantages of using alternative approaches for certifying tax compliance. Still have the report coming in January, but again, it would come from the Office of the Attorney General, and it would be just a more general reference to findings and recommendations for the items set forth in subsection A. Still asks for proposed next steps and legislative needs. And as I was walking through this upstairs, I realized this committee was not listed to receive it. So that was the change I made upstairs, is to add this committee before I got here. So it would come to this committee, Human Services, Ways and Means, and then your Senate counterparts. And that's it.
So, all in favor of the Kornheiser amendment to S 98, raise your hand. All opposed? Okay. 7-0. Thank you, Jen.
Great, sure.
We have about 45 minutes before caucuses. 40 minutes. So Rick is still here, so why don't we keep conversing on S 71?
I'm 11 o'clock got bumped, so I'm free until 11. Let me hold on. I say that. Let me double check. Oh, I have to leave at 11. My 11:30 got bumped, so I'm free after 11:30.
Get caucus at 11:15.
Get a little lunch today.
I think so. I'm not sure about that. Rick Sable, Office of Legislative Counsel again. So shall we continue on 3.3 where we left off? Rep White is nodding, so.
Yeah.
The ranking member is giving me the green light.
Oh, right.
Use the link.
So I am on page 40, that's not the right bill. Page 45 is where I have. Down to the section 2415G, the data protection and impact assessments. Is that where you all have your?
This is still 3.3.
This is 3.3. Yep. Yep. Okay, so looking at the data protection and impact assessments section, there are some changes here, not from last time, but from Connecticut 2025. That state added a requirement to create these impact assessments in addition to the data protection assessments So subsection A, generally speaking, a controller shall conduct a data protection assessment for each of their activities, processing activities that presents a heightened risk of harm to a consumer, which includes the processing for targeted advertising, the sale of personal data, processing of data for profiling, where that profiling presents a reasonably foreseeable risk of unfair or deceptive treatment, financial injury to consumers, a physical or other intrusion upon the solitude or seclusion or private affairs of consumers, where it would be offensive to a reasonable person, or other substantial injury to consumers. And then the processing of sensitive data. So any of those elements would require a data protection assessment. Subsection B details what those assessments should include. They shall identify and weigh the benefits that may flow from the processing to the controller, the consumer, other stakeholders, and the public against the risks to the consumer. The controller shall factor into any data protection assessment the use of de-identified data and the reasonable expectations of consumers. Subsection C is the new language from Connecticut, the impact assessments for profiling. So a controller that engages in any profiling for the purpose of making a decision that produces any legal or similarly significant effect concerning the consumer shall conduct an impact assessment for the profiling. That shall include, to the extent reasonably known by or available to the controller, a statement by the controller disclosing the purpose, use, deployment context, and benefits afforded by the profiling, an analysis of whether the profiling poses any known or reasonably foreseeable heightened risk of harm to a consumer, and if so, the nature of that harm, the steps that have been taken to mitigate that harm, a description of the categories of personal data, processes, inputs for the purposes of the profiling, the outputs of the profiling, an overview of the main categories of the personal data the controller used to customize the profiling, if they use data to customize the profiling, metrics used to evaluate the performance and known limitations of the profiling, a description of any transparency measures taken concerning the profiling, including measures taken to disclose to consumers that the controller is engaged in profiling, and a description of the post-deployment monitoring and user safeguards provided concerning such profiling, including the oversight, use, and learning processes established by the controller to address issues arising from such profiling. Subsection D, disclosure to the AG. Basically, that the AG may require that the controller disclose any data protection or impact assessment during an investigation. The AG may evaluate those for compliance with the subchapter. They shall be confidential and shall be exempt from disclosure under the Public Records Act. And there's attorney-client privilege and work product protection privilege. Subsection E, assessment efficiency and applicability. This ensures that a single protection or impact assessment may address a comparable set of processing operations. If a controller is already making one of these assessments for another state, as long as that state has similar guidelines, then it should also work for the Vermont assessments. It would apply on or after July 1, 2026. And maybe this is the point where you want to change to 2028 to reflect the effective date. Is that a yes? Okay. January 1, 2028, I think is the effective date. Which is July. January. Okay. Subsection F, updating the assessment. A controller shall update the assessment as often as appropriate, considering the type, amount, and sensitivity of the data collected or processed and the level of risk presented by the processing, in order to monitor for harm caused by the processing and adjust safeguards accordingly. Ensure that data protection and privacy are considered as the controller makes new decisions with respect to the processing. Retention, a controller shall retain for at least 3 years all their assessments. H, independent validation for sensitive data. Additionally, the current controller shall ensure that the assessment includes an evaluation and validation of the controller's compliance with the minimum cybersecurity baseline set forth in 2415 EA1D, which is the NIST framework. 2, for an assessment described in that paragraph, the evaluation of compliance shall be conducted or reviewed and validated by a qualified independent person, which is not defined. However, they shall provide a written validation report to the controller that at minimum identifies the information system components assessed and the scope of sensitive data processing covered, states whether the qualified and independent person finds compliance with those minimum baseline, and identifies gaps, if there are any, material gaps, and identifies remediation measures and a reasonable schedule for remediation of any material gaps. This validation report and any supporting documentation shall be deemed part of their data protection assessment for confidentiality, privilege, and retention. A controller that knowingly fails to comply with the subsection by either not completing a validation when so required or including false information commits fraud and is subject to the penalties discussed later. Any questions about that section? Okay. De-identified data, which is a defined term up above in the subchapter. A controller in possession of de-identified data shall take reasonable measures to ensure that the data cannot be associated with an individual. Publicly commit to maintaining and using de-identified data without attempting to re-identify the data, and contractually obligate any recipients of the de-identified data to comply with these provisions. This subchapter shall not be construed to require a controller or processor to re-identify de-identified data or pseudonymous data, maintain data in identifiable form, collect, obtain, retain, or access any data or technology in order to be capable of associating an authenticated consumer request with personal data.
The section is in 71 as, or is it labeled something else?
As passed, I believe there is a de-identified data section. I don't know if it's called that, but it's going to be around the same area towards the end of the bill.
Didn't have.
Yes, so the editors told me we don't hyphen it anymore.
That should be.
Yeah, we remove it. De-identified as one word, no hyphen. 3, require a controller or processor to comply with an authenticated consumer rights request if the controller is not reasonably capable of associating the request with the personal data, or it would be unreasonably burdensome. Does not use the personal data to recognize or respond to the specific consumer who is the subject of the personal data, or associate the data with other data about the same consumer. Oversight, a controller that discloses pseudonymous data or de-identified data shall exercise reasonable oversight to monitor compliance with any contractual commitments to which that pseudonymous or de-identified data is subject, and shall take appropriate steps to address any breaches of those commitments.
Is that in? Trying to find that clause in 71 as passed.
I don't know. If you want to compare it to the draftable, that's what I would use for a quick comparison.
28 for sure.
The
Well, I
oversight,
suppose the real question is, does anybody really care that I keep on comparing it back and forth?
Depends. What your issue is.
I think you kind of get stuck on, it's almost like you have already made the decision. If it's not in S71, then it's no good. That would be my only thing, and I think that's a little unfair of an assessment.
Okay.
2415I, construction of duties. So this term is meant to kind of clarify, it's not quite an exemption section. It's meant to, if there's some type of confusion about what am I supposed to do? What if this conflicts with something else that I have to do? This is meant to clarify that, and every comprehensive data privacy law has a section like this. So the subchapter shall not be construed to restrict a controller's, processor's, or consumer health data controller's ability to comply with federal, state, municipal laws, ordinances, or regulations, except as prohibited by the Shield Law in Vermont. Comply with a civil, criminal, or regulatory inquiry, investigation, subpoena, or summons by a government entity. Cooperate with law enforcement concerning conduct or activity that the controller, processor, or health data controller reasonably and in good faith believes may violate law. Investigate, establish, exercise, prepare for, defend legal claims. Provide a product or service specifically requested by a consumer. Perform under a contract to which a consumer is a party, including a warranty. Take steps at the request of a consumer prior to entering into a contract. Take immediate steps to protect an interest that is essential for the life or physical safety of the consumer or another individual, and where the processing cannot be manifestly based on another legal basis. Prevent, detect, protect against, or respond to security incidents, identity theft, fraud, harassment, malicious or deceptive activities, or any illegal activity targeted at or involving the controller or processor or its services. Preserve the integrity of security of systems, or investigate, report, or prosecute those responsible for the action. Engage in public or peer-reviewed scientific or statistical research in the public interest that adheres to all other applicable ethics and privacy laws, and is approved, monitored, or governed by an institutional review board that determines, or a similar independent oversight entities that determine whether the deletion of the information is likely to provide substantial benefits that do not exclusively accrue to the controller. The expected benefits of the research outweigh the privacy risks. Whether the controller or consumer health data controller has implemented reasonable safeguards to mitigate privacy risks associated with research, including the risk associated with that re-identification. Assist another controller, processor, consumer health data controller, or any third party with any obligations under the subchapter. Process personal data for reasons of public interest in the area of public health, community health, but solely to the extent that the processing is A, subject to suitable and specific measures to safeguard the rights of the consumer, and under the responsibility of a professional subject to confidentiality obligations under law. 13, collect, use, or retain data for internal use to conduct internal research, to develop, improve, or repair products, services, technology, effectuate a product recall, identify and repair technical errors that impair existing or intended functionality, process personal data for the purpose of profiling, in furtherance of any automated decision that may produce any legal or similarly significant effect concerning the consumer, provided the personal data are processed only to the extent necessary to detect or correct any bias. The bias cannot be effectively detected or corrected without processing the data, and the data are deleted once the processing has been completed. Process subject to the appropriate safeguards to protect the rights of consumers secured by the Constitution or laws of the state or the United States. Subject to technical restrictions concerning the reuse of the data and industry standards security and privacy measures, including anonymization. Subject to measures to ensure that the data are secure, protected, and subject to suitable safeguards, including strict controls concerning and documentation of access to the data to avoid misuse and ensure that only authorized persons may access the data while preserving the confidentiality of the data. And not transmitted, transferred, otherwise accessed by any third party. E, perform internal.
I'm going to confess that I don't fully understand the subdivision D, but I'll continue. I'm having trouble following.
This is the AI addition that Connecticut made for the. Okay.
Yeah, I understand. Having trouble following. But I'll continue to.
So it's always internal. It's an internal use, right?
Yeah, it's all about internal use.
Yeah.
True. That was the key, wasn't it? It's just internal use. It's not
They can do these
any
things.
transfer outside the processor.
Right.
Control.
Controllers. Any of them, yes.
Okay. Yeah, so for that reason, I guess I'm not as worried about the detail because it's what it's.
Right, it's meant, again, it's meant to clarify, this conflicts, right, with other parts of the bill, but because it's internal use, it's,
And someone who's
Being-
engaged in this business, it's probably helpful. It just,
very technical. I understand.
but I'm okay because it's just internal.
So E, we're no longer under the, yes, we are. We're still under the internal use. Sorry. E, perform internal operations that are reasonably aligned with the expectations of the consumer or reasonably anticipated based on their relationship with the controller, or are otherwise compatible with processing data in furtherance of the provision of a product or service requested by a consumer or the performance of a contract to which the consumer is a party, or perform internal operations in accordance with internal operations in COPA if they are processing data in accordance with the exception in COPA. Subsection B, evidentiary privilege. The obligations imposed on these entities under the subchapter shall not apply where compliance by the entity would violate an evidentiary privilege under the laws of the state. 2, the subchapter shall not be construed to prevent a controller, processor, or consumer health data controller from providing personal data concerning a consumer to a person covered by evidentiary privilege. Nothing in the subchapter modifies a session law in 2020 that authorizes the use of facial recognition technology by law enforcement, or authorizes the use of facial recognition technology by law enforcement.
What's the reference to, what's the general subject matter of section 14?
So I have not looked at that recently. I can pull it up when I come
That's fine, I
back.
can do it too. I just had a question. I didn't.
Yeah,
I didn't.
something regulating the use of
Yeah.
law enforcement and facial recognition
That's fine.
technology.
That's fine.
Subsection C, third parties. A controller, I'm going to shorten it to entity. An entity that discloses personal data to a processor or third-party controller shall not be deemed to have violated the subchapter if that processor or third-party controller that receives the data violates the subchapter, provided at the time the entity disclosed the data, the disclosing entity did not have actual knowledge that the receiving processor or third-party controller would violate the subchapter. A third-party controller or processor receiving data from an entity in compliance with the subchapter is not in violation of the subchapter for the transgressions of the entity from which the third-party controller received the data.
So
Yeah.
that back and forth.
Yes,
Is someone ultimately going to be responsible if something goes wrong here between the third party and the original controller and processor?
it depends who's at fault, right? So if it's the third-party controller, if they've done something that violates the subchapter unbeknownst to the controller, then the consumer would presumably, they may eventually, the AG or the consumer may target the controller. The controller say, no, it's the third-party controller that did it. So the AG would then go to the third party.
And that maybe that's the issue. Is the third party held responsible to the obligations? Well, I guess they're a controller, right? So they'd be responsible as a controller.
Let me think about it.
Someone.
No, I know what
is
you're talking about.
responsible.
I know, I'm thinking about this.
That's fine.
Because what this section is saying, subsection is saying that the innocent party is not to be held responsible, which I understand this. But your question is whether the third party specifically, if they do something wrong, would they be held under this subchapter to be responsible? for
Under the
their actions?
subchapter,
Right.
not under this.
Right,
but,
right.
You know,
Let's see if,
Right.
so say I have a client database and
Yeah.
I have stuff that I need, but I didn't necessarily ask them, I didn't get consent from them to sell their information. So I use a third-party CRM company,
Okay.
and their job is to store my information, my name, address, phone number, all that stuff of my clients.
Right.
Unbeknownst to me, they go, hey,
Hey,
this guy's got, 500,000
Make some money
people.
here.
We can make some money. So then they turn around behind my back
Yeah.
without my knowledge and sell all of my customers' data to someone.
Yeah.
Well, now they didn't give consent, their data's out there. Well, it's not my fault.
yeah,
So what this does is this protects me.
I understand.
Okay.
I just want to make sure that the wrongdoer is going to be held to account.
Right.
Not you, but I can't remember the entity that you screwed up. And
Right.
they're gonna, and it's probably in here somewhere, I want to make sure that they're gonna be held.
Well, I certainly would not be very happy with.
No, you wouldn't. And the consumer, find out they're probably gonna take off of you, but, it'd be helpful to be able to say, well, the AG can go after that person for the things I didn't. Without my fault.
Right, and because I'm a business and I'm considered a consumer in the state of Vermont, I could certainly report that to the Attorney General,
Correct.
and then they could go after them.
That's what I just want to confirm.
So very good. A plus. I have an answer. So enforcement, which we're gonna get to, there's a person that violates subchapter. So it's not limited to only controllers, processors, any person that violates subchapter. So not only that, but a processor is defined as a person who collects or processes personal data on behalf of a controller or another processor. So if it's an entity that is a controller processor, which presumably they would be here, they would be held responsible. And the AG could enforce, consumer could enforce.
Yeah, I get the person, but so I think the more meaningful one is that third party is a processor under law.
Right, but yes, they would be, but I still think that really is not super important when it comes to enforcement because they would still be an entity violating the law, right? If they're a third party processor.
Yeah, but I don't see a list of third party obligations. So I think it has to relate
They
that.
still have to be a processor, that's what you're saying, which they would be, so,
Okay.
yeah.
I think you were saying that the attorney, it just says person, which
Right.
means it can be anyone.
Right,
It doesn't specify.
to Rep. Olson's point, it's a good point, is that there's no obligation on a person collecting data unless they meet the definition of a processor, right? So to his point, a third party, yeah, I think it's okay. Yeah.
Sorry to take time.
No,
Good.
okay, so third parties, D clarifications. The subchapter shall not be construed to impose any obligation on a controller or processor that adversely affects the rights or freedoms of any person. 12 VSA 1615, is that journalism? I need to remember that cross-reference. Thank you for
Oh, no, it's Dr. Patient.
occupation?
Dr. Patient.
Doctor patient privilege, okay. Maybe Rep. Priestley can quickly look it up. 2, apply to any person's processing of personal data in the course of a person's purely personal or household activities. 3, require an independent school as defined in 16 VSA 11A8 or a private institution of higher education to delete personal data or opt out of processing the personal data that would unreasonably interfere with the provision of education services by or the ordinary operation of the school or institution. Personal data processing. Personal data processed by a controller or consumer health data controller may be processed to the extent that the processing is A, reasonably necessary and proportionate to the purposes listed in the section, adequate, relevant, limited to what is necessary in relation to the purposes in the section. Personal data that is collected, used, or retained pursuant to 813, which is the internal use exception. shall, where applicable, take into account the nature and purpose of or purposes of the collection, use, or retention. The data shall be subject to reasonable administrative, technical, and physical measures to protect the confidentiality, integrity, and accessibility of the data and to reduce reasonably foreseeable risk of harm to consumers. If a controller or consumer health data controller processes personal data pursuant to an exemption in the section, the controller bears the burden of demonstrating that exemption. 4, processing personal data for the purposes expressly identified in the section shall not solely make a legal entity a controller or consumer health data controller with respect to the processing. I think that's, we're talking about construction of duties, right? So I think it's not going to affect anything else.
Cool.
2415J enforcement. So the Consumer Protection Act, a violation of the requirements of the subchapter shall constitute an unfair and deceptive act of commerce. Enforced solely by the AG, subject to the exception set forth below. Pursuant to 2461B, which is that right to civil action, a consumer may bring a civil claim for a violation only against a person whose annual gross revenues exceeded $1 billion in the previous calendar year. The AG has the same authority to adopt rules and conduct civil investigations, enter into assurances of discontinuance, bring civil actions, and take other enforcements as provided under the Consumer Protection Act.
Time for discussion of this? Or just, we're just looking at this?
When we finish, this is,
You want to finish with Rick and then we can,
well, let's finish
One more
this page
oh, okay.
and then we can,
Yep,
we've just gotta go.
super. Yeah, you're right. Yeah.
Penalty for fraud, a controller that's committed fraud, which is the impact assessment category for sensitive data. If they knowingly don't do one or lie in their impact assessment, they are liable of a penalty not less than $10,000 to the state and not more than $25,000 for each act that would be a violation. And 3 times the amount of damages that the state sustains because of the act. And the costs of the investigation and prosecution of the violation. Also under enforcement would be reporting from the AG. Each year, the AG shall submit a report to the assembly disclosing the number of notices of violation they issue, the nature of each violation, the number of violations that result in enforcement, and the number of enforcement actions that precede the trial, and any other matter the AG deems relevant for their report. Was there? Keep going or should I stop?
No,
Okay.
finish it.
Okay, so consumer health data privacy, except as provided in 2415I and 2415B, no person shall provide any employee or contractor with access to consumer health data unless the employee or contractor is subject to a contractual or statutory duty of confidentiality. Provided the processor with access to consumer health data unless the person and processor complies with 2415F. Or use a geofence to establish a virtual boundary that is within 1,850 feet of any healthcare facility, including any mental health facility or reproductive or sexual health facility, for the purpose of identifying, tracking, collecting data from, or sending any notification to a consumer regarding the consumer's health data. The effective date is Jan 1, 2028.
That's unique to them.
The effective date? Yeah. Yes, it is. One other state may be considering Jan 1, 2028. I don't know. Yeah.
Can I, while we're still here, the consumer health data privacy,
Yes.
how does that fit into the other provisions of the bill around controls, processes, and personal?
It's extra.
Because it seems like most of the bill deals with maybe some of, at least, what's in this particular section. So I'm trying to, well, number one, I'm going to make sure that the rest of the bill, in fact, does apply to processing and controls of health data. Which I'm assuming is the case. But I was just trying to figure out what what this happens. And it might be a good thing that it's added.
So it's extra protection for that kind of data. So
Extra.
yeah, so throughout the bill, I typically said controller processors and consumer health data controllers when I discussed some type of, all three of those were lumped together typically. So the 2415I, this is the construction of duties where sometimes internal use, right? Those are
Right.
exemptions to some extent. 2415CB, this is the actual exemptions. And then the B, I believe, is COPA. Yes. So absent those things, 1, 2, 3 apply. So these are extra protections for consumer health data that may not be included in the rest of the bill, to where you want to make sure that this type of data is extra.
Okay.
I'll use the word sensitive because it's not labeled as such, but it is to this bill to be handled differently.
Okay, thanks. Anything else? Richard's still here. I'll just say that I don't want to jump ahead of the conversation around enforcement. Something in the draft here. John Taylor. But if that doesn't carry forward, I have an alternative way to try to get the AGs and resources. And I forwarded it to Rick, but fairly recently. I don't know if he has any thoughts about that or if he could do that way. I know he's leaving, that's all. And I also forwarded to a provision around TPAs to Rick and Jen. But again, it was probably pretty recent.
Okay. The enforcement pieces that, we'll start backwards, how our way to.
Okay.
Where's, we saw private right of action, here's committee on that.
I think it's a good thing. I think the caveat there is that you're talking about entities with over $1 billion in annual revenue. So I really doubt that. I think that it's kind of some additional enforcement beyond just what the AG has right now is, I think, kind of necessary to do legal battle with some of these really big companies.
Others?
I don't see it's a necessity as written. I don't see it's like you either have it or you don't, and I don't know about the threshold that's placed doesn't seem. I'm comfortable without it. I don't think it, I mean, it's slightly different from other consumer protection resources or, what's available to people, but I don't think we need it, given all the other protections that are in there.
I would concur with Jonathan in that thought about the PRA. And once that threshold is in there, once the language is in there, that threshold will be fair game in the future to adjust as others also see fit. Well, without it, I believe.
Yeah, I kind of agree. It feels a little bit, or, I mean, again, it's $1 billion is a huge company, but kind of agree, either we have a PRA or we don't. It's a little bit arbitrary, sets businesses up just to create corporate structures. Like, how do you even measure that? And what is the,
Does anybody want to hear me speak? Because if not, that's fine. I can just be quiet. Yeah.
Just be concise.
Hey, this is very frustrating for me to because I'm looking at all the things that are happening. If we modify this bill, we pass it out here, it goes to Senate institutions, because that's where it came from, correct? Believe it came from, did it come from Senate institutions? So we'll go back there, it'll come out whatever way it was, and it will end up on the governor's desk with a veto. And then and I know that there's some people that are perfectly fine with not having that or having the veto. And that's great. I mean, if that's what you want, we have, yeah.
Right now, we,
This little topic.
No PRA, no PRA. That's
Right.
That's concise. That's all you.
but right now, we don't have anything to say. Okay? So we don't even know what that product's gonna look like. Product that we send over may very well allow the governor to sign it. We don't know that yet, so let's not get ahead of ourselves.
I have a legal thing to think about. After I'll drop this and then I'll leave. So whenever you, and the bill has this with the thresholds and the applicability, when you start limiting lawsuits, you start limiting who's applicable to a law, you do have some constitutional issues that may come up. Why are big businesses targeted? And you can come up with a reason, but there must be a reason. So what's the reason? And you want to maybe make that clear on the record of why a $1 billion business is more is susceptible to a lawsuit while a $999 million company is not. And it's a rational basis test. It's just a legitimate, what's the legitimate interest? And not just the $1 billion lawsuit, but also the applicability. Why 35,000 consumers? Why not 34,000? Why not 100,000? Right? So I haven't really talked about that, but that is something that, a court could say, why is Vermont, why is Connecticut, why is Maryland restricting it to certain businesses? So just something for your discussion to consider.
Yep. 11:15, the Republicans have a caucus, I believe the Democratic caucus has changed to 12:30.
Yes. I'll pick back up here later, or,
I don't know, it's gonna depend on what the floor looks like.
okay.
You are free at 12:15, you said?
I'm earlier now, probably around 11:45, 4:12. I'll be clear.
Noon, room 44. Okay, thank you.
Just for the record, then I totally understand this was put in there as just to have the discussion about this. I think as we heard from Vermonters who are testifying, that we are essentially like stripping Vermonters of rights that they have under the Consumer Protection Act, of which this goes into. And we, with every other consumer protection law, whether it's car safety or whatever, like we provide people, including kids code and everything else, we provide people with, if they are harmed, the ability to go to court to represent themselves. The AG has testified that they do not represent individual Vermonters, they represent the state. And if something rises to the level of the state making sense to spend the money going after it, then they will consider doing it. But otherwise, I'm concerned with how many people will be harmed that are blocked from going to court by this law. Seems to not even reference the underlying Consumer Protection Act, which requires harm to be proven, which is a really high bar on this kind of stuff, and often could actually be too late and have done a bunch of damage. I am really concerned that when this data is used to harm people, they don't have the ability to go to court. And additionally, I also think we really haven't talked about the fact that data privacy and trying to minimize the amount of data that systems are using is the fundamental baseline of every digital protection, consumer protection law, as well as every artificial intelligence law that we are hopefully going to eventually be able to start working on. And if we are stripping the ability for a consumer to access the court system on privacy harms, are we also going to be doing that for things that are, as dangers increase and harms increase in ways that can affect every aspect of their lives? And so I just hope we're like considering that this is the base and we are stripping the base of which we are going to build upon for other future digital protection laws.
I think that we also have people that like to see ads for shoes that they're gonna maybe wear. And we have these people the public seems to have a great appetite for convenience and for ease of use and for, just like everything else in life, less friction. And it's become, I cannot recall through the testimony that we've heard, people saying this happened to me because of this. I can recall people saying, structurally, this is messed up because here's what can happen. And those aren't the same to me. And I was just trying to find the website's a little slow right now, but I want to go back and find the witnesses we've heard from who have said, this happened to me because of a lack of consumer protection within data privacy. And I don't discount it. I just need to go refresh my memory on it. But we haven't really had that in mind, at least in terms of the problems we're looking to solve, the problems we can articulate versus the problems we are experiencing. And there's been a disconnect for me there. I think the point is well taken that there are consequences to, say, not having a private right of action. We may also find that we are frustrating and annoying consumers. And I'm still trying to work that out.
At 11:15, we had caucus. Depending on how long the floor goes this afternoon, we'll come back and we'll continue some committee discussion. And I get rid of in all this area. My right of action is divided committee, so we can talk it out and we'll see what happens. So with that,
Can I circulate? So the exam authority kind of thing. I have something I sent to Rick in district. Is that okay to circulate that?
Yeah.
Because we might not get back together.